It's a pleasure to follow the Honourable Gentleman from Swindon, and indeed many of the colleagues that have sat next to him, who have brought an immense level of legal expertise to their concerns about this legislation. Let me try to offer something different then, as somebody who is not legally qualified, a lay person's view or perspective about what this legislation is doing, and in particular why I have tabled and speak to Amendment 9, but obviously I support the amendments in the name of my front bench colleagues. This is actually not for me about the R of refugees or even the R of Rwanda. It's about the R of rights, and the rights that we enjoy that protect those freedoms and liberties to which so many of us fight for, are passionate about, and believe are intrinsic to a good life. This piece of legislation that the government has stated itself is a clear statement of the Parliament's view that Rwanda is safe, notwithstanding all specified domestic legislation and the common law and any alternative interpretation of international law, including customary international law. Now, for those of us who are not qualified, the word notwithstanding there is doing an awful lot of work to justify the diminution of rights for people in our country, and the concept that somehow international law does not protect us. And so much of the anger that we have heard, the concept, the idea of a foreign court, has come from it being about the European Court of Human Rights, that it is an affront to our democracy that this organisation is part of protecting those rights, those liberties, those freedoms on which we depend. How dare Winston Churchill sign us up to such a thing? How dare he believe that working with other countries was the way in which we protected those rights? As he said, in the centre of our movement stands the idea of a Charter of Human Rights, guarded by freedom and sustained by law. The scoundrel. What sort of rights was he trying to protect? What sort of abuses by the state did he dare to think we might need a court to uphold for us? The right to family life? A travesty, surely. The right to privacy? I mean, goodness me, what a terrible thing to be concerned about. The right to freedom from torture, or the right to liberty, or even the right to freedom of thought? Well, no wonder we need to look at all of this again. How terrible those things must sound to those of us who are not legally qualified, who cannot see the rub there. Let me try and think through a real-world example, perhaps, Madam Chair, of why those rights might be upheld by a third party. One could think of somebody, say a member of this House, who didn't have the respect and courtesy for other people speaking in this debate to even stay and listen to them shortly after he had spoken. Somebody who thought the rules did not apply to him, that the treatment of other people was not something that mattered, who perhaps was far too busy worrying about his social media account. Rightly so, Madam Chair would want to hold him to account. Goodness, many of us would think he might need legal representation for what could happen next. He would want his day in court. Oh, he might not want to be in the chamber when we were talking about those very issues. He might certainly be concerned about the idea of a judge and jury existing in the same person. The very principles that led to setting up the European Court of Human Rights are ones that we all feel every single day, because the Court of Human Rights does not just defend those basic things like a right to family life or the right to privacy. It also defends a process by which those rights are upheld. But even if Madam Chair wanted to take somebody to task, they might at least be entitled, for not following the rules in this place, they might at least be entitled to a fair hearing, a fair trial for what they had done. Yet what this legislation does is remove that concept of a fair hearing from those people in our country who are often some of the most vulnerable, people fleeing torture and persecution. They want to uphold in government ministers, judge and jury, which doesn't even abide with their own data on how many people they were actually granting asylum to when their cases were heard. But nevertheless, the point about the ECHR is a point that Churchill understood, and I believe many of us in this chamber understood, is that we withdraw the opportunity for that freedom to be heard and that freedom for a fair trial and for somebody else to hear your case against an overbearing state at our peril. Article 13 of the European Court of Human Rights Convention sets out the right to an effective remedy, and it dares to impose on state parties, on countries that are signed up to this court, that everyone whose rights and freedoms are set forth in this convention are violated shall have an effective remedy before a national authority, notwithstanding, that word again, that the violation has been committed by persons acting in an official capacity. In layperson's term, when you think the government has done you wrong, who do you turn to protect you? Now, rightly, you might want to turn to our courts, but if the government is setting the laws, it makes sense to many of us who value freedom and liberty that there is a third party that you can adhere to. And frankly, it's a sign I'm getting old that I look at the Conservative Party now and I wonder where those libertarians are, those people who recognise rightly the concern that a government might be overbearing and repressive. Freedom-loving indeed, but not enough for their own freedoms, it seems, from the way in which this piece of legislation starts that inevitable process of removing that right to a remedy. Because we all know right-wing governments might start with refugees, but they never end with their rights when it comes to removing them. Now, removing the right to an Article 13 remedy, which is what this legislation does, doesn't just have consequences for refugees, and many of us have debated that issue, that concept that each person should be able to have their day in court, a concept that laypersons across the world understand, for it is not just written into the European Court of Human Rights, into our Human Rights Act, it's written into the United States Convention. I don't think it really is some terrible communist, socialist, Marxist idea that people might have a remedy. That idea of due process, it's part of being a state that plays by the rules, that treats people fairly. And if we start to unpick that in this legislation, it does not just have a consequence for our immigration system, it has a consequences far beyond the remit I think that anybody has really thought about, because for so long it has been a byword for British liberty and freedom that we've been prepared to stand up for the rule of law and play by the rules, and yes, be part of making them through being part of the Council of Europe. And I declare an interest as somebody who did take part in one of those elections to vote for one of those terrible pyjama-wearing judges who then has to uphold the legislation that we have helped create. Where does it have an impact? Well, the member on my side, whose constituency I've just forgotten because I am getting old, I'm sorry, I do apologise, talks about the Good Friday Agreement, and the member from Swindon recognised that too. Let us sound the alarm here, if the government will not deal with it now, that it must be dealt with in the other place, because peace is precious. And the peace in Northern Ireland was built on the bedrock of the Good Friday Agreement, and the Good Friday Agreement is built on the bedrock of the European Court of Human Rights. It's baked into the Northern Ireland peace process. The Good Friday Agreement placed a direct duty on the UK government and all of us in this place to incorporate the European Court of Human Rights and its work into Northern Irish law so that people in Northern Ireland could challenge an injustice in the courts if their rights were breached. That's not my interpretation. The Good Friday Agreement explicitly says full incorporation into Northern Ireland law of the ECHR and states explicitly that the parties, i.e. us and the Irish government, affirm their commitment to the mutual respect, the civil rights and the religious liberties of everyone in the community. When we start removing those rights, which what this bill does by denying the right of a refugee to go to court under Article 13, then we start undermining the Good Friday Agreement because it does affect people in Northern Ireland. It's a principle established in law through Section 7A of the Withdrawal Agreement. Now, the government actually acknowledged this when we debated this on the 12th of December. The Home Secretary himself acknowledged that the bill makes differential treatment in different parts of the United Kingdom and that somehow the bill would address these practical implications. But we've not seen any practical addressing of the implications and the consequences that that might mean for our commitment to upholding the Good Friday Agreement. An agreement that I think we would all concur 25 years on still matters and therefore is worth fighting for. And it matters because refugees are people too. I don't know why we have to state that in this place, but it does increasingly feel like we must do. And the member is right when he talks about the Anderson ruling, but the Anderson ruling shows that the government recognised that just a few months ago, because the government in the court said that it applied to refugees. Section 108 explained explicitly that the applicant and the respondent both agreed that the rights and safeguards and equality underpinned by the Good Friday Agreement are not excluded from asylum seekers, and that the concept of who everyone in that community was that is written into the Good Friday Agreement included those outside the background of communal conflict. So we could be in a position where it's a frying pan and a fire, because if the government proceeds with this piece of legislation, we undermine the Good Friday Agreement. But yes, if they exempt Northern Ireland from this so that those rights are upheld, they create the loophole that I'm sure members on the other side of the benches, I'm not sure which part of the mafia contingent that refers to these days, will recognise creates a loophole in this legislation and just reflects the further chaos and confusion that the government's Rwanda legislation causes. I have tabled Amendment 9, therefore, to address this issue head-on. It asks the government to do a very simple thing, which is set out how we are upholding the Good Friday Agreement through this legislation. Surely that is not a controversial question to ask, but it seems very controversial to get an answer. It's not just the Good Friday Agreement that messing around with Article 13 unpicks. It's also part of our trade and cooperation agreement, because again, when we're doing international treaties, evidence that we play by the rules and therefore we're good to do business with is part of why other countries want to work with us. And that matters post-Brexit, because our reputation is everything. And time again, this government has sought to undermine it by suggesting that somehow the rules shouldn't apply to us, and that therefore people shouldn't expect the United Kingdom to stand up for those values and abide by upholding them altogether. Article 524 of the Trade and Cooperation Agreement says the cooperation provided for in this part is based on the parties and member states' long-standing respect for democracy, the rule of law, and the protection of fundamental rights and freedoms of individuals, including as set out in the Universal Declaration of Human Rights and in the European Convention on Human Rights, and on the importance of giving effect to those rights and freedoms in that convention domestically. Giving effect is the crucial thing here. Again, as a layperson, it makes simple sense to me. There's no point in having rights if you can't actually use them, if there is no court, if there is no possibility of being able to seek a remedy. And yet that's exactly what this piece of legislation starts to unpick. It's not a surprise to me, therefore, that the chair of the committee in the European Parliament, Natalie Ozzo, who is charged with overseeing the Trade and Cooperation Agreement, recognises this legislation unamended for what it is, which is a direct threat to that. And the worry that many of us have is not about Brussels telling the UK what to do. It's the fact that we are heading into the months and years before the Trade and Cooperation Agreement is going to be renegotiated. And next time somebody in your constituency comes to you with all the paperwork that Tory hard Brexit has created and that TCA underpins and asks you what you're going to do to deal with it, when they come to you about the border tax that's going to come in at the end of January and all the paperwork they're going to have to pay for at the end of April, that opportunity to reduce that and remove that and bring back that trade we desperately need will depend on those negotiations. Walking into them showing that you can't trust a word that we say as a country, because we might say we're going to follow the ECHR, but actually if we think it doesn't suit us, we won't, and what are you going to do about it, is not the way to get a good deal for British business. So there are consequences to the way in which this legislation has been drafted that we haven't even begun to unpick in this House, but today is our last day to do anything about it. We must not look like a country that you don't want to do business with or is hypocritical, and yet that is frankly exactly what we are. And for those of us who have fought for and defended the rights of people we disagree with, that hypocrisy stinks loudly from this Home Office, because the same Home Office that wants to use the European Court of Human Rights to deny the implementation of the buffer zones that this Parliament voted for on the basis that there would be an Article 9 contention under the ECHR, is the same Home Office that is seeking to rip up the rights of refugees to use the ECHR when it feels like it. Sauce for the goose, sauce for the gander. In layman's terms, everybody can see what is going on here. Picking and choosing to suit your own ends, and the consequences for people be damned. This bill is contrary to the rule of law because it amounts to a legislative usurpation of the judicial function. It's an assault on our constitution. It is not standing up for liberty and freedom. It's denying it by removing those basic rights. And the government is doing that in its own legal assessment. Now, I earlier raised this with the member opposite. I mean, again, I'm not legally qualified, so I read this, and I think it reads like something out of Alice in Wonderland. It says that Article 13 in the ECHR is engaged but will not be infringed. I mean, that feels a bit like present but not involved as a way of thinking about legislation. It seems to be saying that because we can say that Rwanda is safe and will always be safe, there can never be any concerns raised about safety. It's a tautology. It doesn't make any sense, not least with the evidence that we have that Rwanda does have concerns about safety, or indeed the possibility that things might change in future even if you don't accept the evidence of extrajudicial killings, deaths in custodies, enforced disappearance and torture, and the persecution of those from the LGBTQ+ community. It's not just that it says that. It then goes on to what I believe is a bit more like the Mad March Hare. It's from the government's own legal position. It says that the government considers a declaration of incompatibility is sufficient to provide an Article 13 effective remedy for challenges to decisions under the presumption of safety in Clause 2 to treat Rwanda as safe. For those of us who are not legally qualified, saying something is incompatible to make it compatible, because basically what you are saying is that means somebody can bring a court case. Well, that just means that this piece of legislation is a lawyer's charter. Now, the government keeps telling us they don't like lawyers, but they seem to want to encourage them to make a lot of money out of badly drawn pieces of legislation that will encourage court cases. But that's exactly what the government's own legal ruling does. This House can and should do better. This amendment before us is about resolving these challenges, showing that we have thought about them. If nothing else, it would give succour to the court that we had, as we did with prisoners voting, considered the matter, which is often what the court is asking us to do, to not leave people's rights locked away, unable to be accessible, but actually to look at how they are being used. Churchill said that they would welcome any country where the people own the governments and not the government the people to the courts. I think a very noble provision. I'm sorry that members opposite are increasingly advocating removal from the European Court of Human Rights because they can't live up to those terrible ideals of a protection of a right to family life or a protection of privacy or, goodness knows, a protection of freedom of thought. Oh, go on then.
By constantly and sarcastically evoking Winston Churchill. And obviously he did sign up to the ECHR and he sent lawyers to the drafting process of that. But does she acknowledge that, firstly, he didn't initially think that the United Kingdom would join it in the first place? Secondly, when he did sign us up to it, there was no right of individual claim to the European Court. It was properly on the plane of international law, which is between states, which is the appropriate place for this sort of law, and nor would he accept, surely, nor should any of us, what the ECHR has become under the jurisdiction of the Strasbourg Court and, I'm afraid to say, our own lawyers. And all the articles she mentions, including the right to family life, have been so expanded by the courts ever since, that it's become absolutely inappropriate for us to belong to the court in this way. I really do not think that Winston Churchill would have supported what Strasbourg has become. She doesn't either, surely.
I'm sorry that the Honourable Gentleman wasn't here earlier to be part of the conversation again. I'm sure he would want his own right of remedy to explain why he couldn't be bothered to be here at the start. He would have heard the debate that we had about what the original intention of the court was. Let me quote back to him the original document that says, "High undertaking parties agreed to abide by the decisions of the court in any case to which they are parties." From the start, and Churchill himself advocated from the start for the court as a backstop against overbearing governments that felt that it could speak for its people and prosecute people in ways that were being talked about post the Second World War without any challenge. I don't quote Churchill sarcastically. I recognise what he saw at the time, the danger of authoritarianism, and the member opposite would do well to go back and reflect and perhaps reread some of those challenges, as well as the rules about taking part in a parliamentary debate. When Churchill talked about welcoming any country where people own the governments, it was about democracy. And our courts are an integral part of our democracy because they do keep governments honest, even if they're straining with this current administration. Just 2 countries have left the European Court of Human Rights. I was there when we expelled Russia because of its aggression, and we tried to prevent them coming back. And Greece left in 1967 under a military regime and then rejoined once democracy was restored. We should be proud and confident of our capacity to speak up for human rights and to recognise that a right to an effective remedy is an integral part of that, that it's no point having a right if you can't then exercise it, and that means having a separate body to be able to oversee them, to be fair to all parties. More pragmatically, we should be worried about messing up our trade deals and undermining peace in Northern Ireland, as this piece of legislation does. Let me say honestly to the member opposite, it's not woke to be libertarian, to not trust governments and think that we need to protect us. It's whack to think that because your government is in charge, it's okay because it won't abuse that power. All governments try to do that at some point, and it's right that all governments face a process of challenge. This legislation won't stop the votes. What you really want to do is stop the vote, and you can't do that as a government. There will be an election, but not before we have done potentially irreparable damage. Now, the Irish government has yet to say what it thinks about this legislation, but the UK government in that ruling in October was clear that it felt that refugees were covered by the Good Friday Agreement. So in tabling this piece of legislation, this government is undermining its own logic about its obligations under the Good Friday Agreement. So even if members opposite do not care about the Trade and Cooperation Agreement, let us at least care about the peace process. Let us ensure that these issues about compatibility are not something out of Alice in Wonderland, but speak to the best of this place and those obligations, because I promise we shall all regret it if we do not speak up for freedom and liberty in this way.